today's civil seminar. It's the second civil seminar we've had this academic year. Our speaker today is Susanna Leong. I hope I pronounced that correctly.
Yes, thank you.
Susanna is a visiting researcher. She's been here with us. She's going to be with us for the duration of the Michaelmas term. She's visiting us from the University of Singapore, where she's a professor of law in the Business School of the National University of Singapore. She is going to be talking to us today about a topic that has increasingly sort of pushed its way into the forefront of modern copyright law, which is intermediary liability. And if I've understood correctly from the abstract, she's going to be focusing specifically on the tricky question of allocating responsibility between different parties in cases of online copyright infringement. So, Susanna, we are very glad that you could be with us tonight.
Thank you.
Yes, so without further ado, the floor is yours.
Thank you very much. Thank you very much, Professor Christina, for the kind introduction. And good evening, everyone. First, I would like to thank Professor Bentley and Hanning for the kind invite and the opportunity to speak this evening. And the topic that I have chosen is Internet Intermediaries and Copyright Infringement, Who Makes the Copy? So what I'm proposing to do this evening and what I hope to achieve is as follows. First, I will take you through a macro overview of the historical background and the development of legal models or approaches to the liability of Internet intermediaries for infringement of copyright. In the process, we identify various possible scenarios in which copyright infringement may take place in the Internet and the roles intermediaries play in bringing about the alleged infringing acts. Then I will move to zoom in, if you like, to focus on a micro issue, and through a comparative analysis of court decisions across different jurisdictions, I hope to demonstrate, or at least to highlight the challenges that the courts face in terms of allocating legal responsibility between different players in a spatial dimension such as the Internet, where the roles of these intermediaries or their roles as content producer, intermediaries, and consumers, they are not necessarily always clear and distinct. So this is what I propose to do, and I hope I have enough time to achieve this. So since its inception, we know that the Internet has had a profound impact on society. Advancements in technology, especially the information technology, and all the activities now on the Internet has given rise to the issue of intermediaries and the legal liabilities. The areas in which intermediaries may be found liable as a result of the content authored or supplied by third parties in the Internet include not just copyright, but also other areas such as pornography, defamatory contents, or hate speech. This particular topic is a big area, a big topic, and it's complex, and there is a lack of consensus, I would say, about what is the right terminology to use in the discussion of this issue. And academic opinions are divided. Now, from the economic perspective, in economics literature, intermediation refers to the process by which a firm, acting as the agent of an individual or another firm, a buyer or seller, leverages its middleman position to foster communication with other agents in a marketplace that will lead to transactions and exchanges that create economic and or social value. Now, in the context of the Internet, what are intermediaries and their various types? So this is the question that we must first address. And for the purposes of this evening's talk, And in our discussion of copyright liability in the internet, we employ the term internet intermediaries and rely on the definition proposed by a recent report of the OECD. And internet intermediaries, in this particular report, internet intermediaries bring together or facilitate transactions between third parties on the internet. They give access to, host, transmit, and index content, products, and services originated by third parties on the internet, or provide internet-based services to third parties. Now, this proposed definition of the term internet intermediaries is, in my opinion, wide enough to include business entities such as internet service providers, data processing and web hosting providers, internet search engines, e-commerce platforms, participative network platforms, and e-payment systems. It is important to note that, this is a footnote, that we are relying on this proposed definition to help us understand what internet intermediaries do. But we do not necessarily rely on this proposed definition to demarcate responsibility, copyright liability of these intermediaries in the internet. So that is the little footnote here, all right? So in terms of liability of internet intermediaries for content authored by or activities carried out by third parties, a historical overview, the beginning, right? Limited liability of internet service providers. Now, in the early days of the internet, emerging internet companies, in particular internet service providers, or we call them ISPs, sometimes also network service providers, NSPs, they were concerned about their liability for contents authored or supplied by third parties, notably libelous, defamatory, or pornographic contents, which were either criminally or civilly actionable. Now, ISPs argued that in the architecture of the internet, their function is to connect its subscribers to the internet by supplying telecommunications, facilities, and access equipment. Since ISPs have no effective legal or actual control over the contents authored or supplied by third parties, it is inequitable to impose liability on ISPs. At that time, a strong argument was also made that from a public policy perspective, it is necessary to limit the liability of ISPs so that resources and investments would continue to be injected into the nascent internet industry sector. When assessing ISPs' copyright liability on the internet, these same arguments serve to shape the limited liability paradigm. The limited liability paradigm developed in two main legal models of the world. One is the Digital Millennium Copyright Act, DMCA, in the United States, and the Electronic Commerce Directive in the European community here. Now, under the limited liability regimes, copyright law treats an intermediary, such as internet service provider, as a mere conduit that facilitates access to information on a network. As such, an intermediary should, in general, not be held liable for copyright infringement in respect of its role as a mere facilitator or intermediary. Now, copyright liability of an intermediary is limited for infringements that it does not control, does not initiate or direct, but that nevertheless takes place through systems or networks controlled by it. And so long as it expeditiously takes down or disables access to infringing material when served with proper notice from the copyright owners, they are safe. So there's also termed safe harbor provisions. Now, the limited liability regime and its signature notice and take down provisions, they were not free from concerns and criticisms. One primary concern is that ISP, armed with the notice and take down provisions, may exert an unintended effect in the form of privatized censorship on free speech. These concerns are augmented by research which supported the claim that ISPs for fear of losing their immunity, often erred on the side of caution, and they were more inclined to take down or block access to notified contents without adequate prior investigations. So relevant legal provisions were then fine-tuned to address these concerns. So in Singapore, counter notification provisions were introduced in our Copyright Act by the amendments in 2005. The change in the law, we hope, to create a better balance between the interests of right owners and the ISPs by ensuring that the benefits of immunities that ISPs enjoy, they are accompanied by certain responsibilities. That over the past 2 decades or more, of course, the internet industry grew rapidly, right? And before long, the emergence of new, now not so new, all right, online intermediaries, especially in the application layer of the internet architecture, such as search engines, P2P technologies, auction sites, aggregators, and comparison sites, participative network platforms provided novel ways to enable or to assist copyright infringement. The possible scenarios and the roles played by these internet intermediaries in bringing about copyright infringement are as follows. Number 1, the first type, all right, internet intermediary offers content for streaming or download. The internet intermediary in this scenario is often a website operator. 2, internet intermediary hosts third-party postings of content for streaming or download. Again, the internet intermediary in this scenario is often a website operator. 3rd, internet intermediary provides links to website offering content for streaming or download. Here, internet intermediary may be a website operator or a search engine. 4th, internet intermediary provides the technology that enables users to share files containing works protected by copyright. The internet intermediary here, in its most state-of-the-art form, is, for example, the BitTorrent approach or protocol. 5th, internet intermediary that enables user to reproduce content, such as remote storage digital video recording service, RSDVR, and similar services. And examples of these RSDVRs, internet intermediaries, Record TV in Singapore, TV Now in Australia, Maneki TV in Japan, Aerial in the US, TV Catch Up here in the EU. One high-profile internet intermediary, I think you will agree with me, that we can think of is Google, right? And indeed, Google has been sued for, amongst other things, indexing and making available subscription-only adult images, for aggregating third-party news contents in Google News, for enabling users to share the unlicensed posting of videos. This is Viacom's suit against YouTube, a subsidiary of Google, and so on and so forth, right? Proceedings were also brought against other internet intermediaries such as Cooper and iNet in Australia, Scarlet in Belgium, Baidu and Tudou in China, and Record TV in Singapore. Copyright owners also sued and won against internet intermediaries which provide the technology that enables users to share files containing works protected by copyright. And we have Napsters, Aimster, Grokster, Kazaa, LimeWire, and so on. In all of these proceedings, internet intermediaries were sued as indirect infringers, but sometimes they are sued as direct infringers as well, in that they operate equipment and services that facilitate copyright infringement. Amidst these mounting claims, a response is necessary, and policymakers all over the world needed to recalibrate the policies and enact new laws. Judges are required to interpret existing legislation, formulate rules to allocate legal responsibilities for the infringing conduct of intermediaries. Judicial solutions in civil and common law jurisdictions include recognizing claims in authorization infringement, vicarious and contributory liability, inducing infringement, joint tortfeasorship, aiding and abetting, and negligence. Administrative solutions were also introduced, and these were the graduated response laws that were adopted, the 3 strikes, all right, graduated response laws that were adopted and enacted into laws in countries such as South Korea, the UK here, and France, New Zealand, and Singapore. So that very quickly, all right, is the macro overview. And because of time, I'm not able to go through all of them in terms of the scenarios. So I have chosen to focus on the 5th scenario, which is the copyright liability of internet intermediary that enables users to reproduce content such as remote storage digital video recording services. Because in this particular scenario, there were several decisions across jurisdictions. Again, all right, I feel that the grounds of decisions are interesting to study and to discuss. So a very quick, summary is that we have a court decision in Singapore, there's Record TV. We have a court decision in Australia, TV Now. There's a court decision in Japan, Manaki TV. A court decision too here, TV Catch Up, and Ariel in the US, right? I'm going to just focus on 2 decisions. I've chosen to make a comparison between the Singapore decision, Record TV's decision, and the Australian TV Now decision. And the reason for doing so is because from a comparative legal analysis point of view, Singapore's Copyright Act of 1987 is modeled largely on the Australian Copyright Act of 1968. So we have a similar factual situation, and we have laws that are modeled, all right, modeled on, all right, Australian law. And so to me, it's interesting to look at these 2 decisions because they came to complete different conclusions, all right? And Australian case law, I think, continues to play an influential part, I think, in our courts. Our judges, they like to look at court decisions elsewhere when writing the grounds of decisions. So I'm going to focus on this, and this is what I now move into a micro issue, all right, and to highlight the challenges that the court face. So the first inquiry, all right, that comes to mind, if there is indeed copying, all right, then who makes the copy? In a digitized environment, the question who makes the copy may not be as straightforward as it appears. Just as by way of background, all right, I mentioned just now the cases in the various jurisdiction. In record, well, what we are concerned here is essentially a subscription service on the internet, which operates like a video recorder, like a physical video recorder, that you're able to therefore copy content and view it later. All right, that is essentially the service that's provided by the internet intermediaries. Now, in terms of this inquiry, who makes the copy? In Singapore, the court found that it's the user who made a copy. In Australia, they rejected this conclusion, and the court came to the conclusion that it was a service, maybe also the user, together with the user, all right? In Japan, it's the service that makes the copy. In TV catch-up, I think it's also the service here, all right? Individualized transmission is the service. And in Ariel, in the US, court concluded is the service. So of these the court decisions, it appears that Singapore's record TV is an outlier, all right, where the court ruled that it's the user who makes the copy. So in record TV and MediaCorp, the Singapore Court of Appeal was asked to rule on this copyright liability of providers of internet time-shifting record services or free-to-air television programs. Central in the analysis of the copyright liability of Record TV. Record TV is the internet intermediary that provides this service, who may be considered, all right, intermediaries as its time-shifting recording services on the internet provide subscribers with the means to make copies of free-to-air television programs. It's the scope of the exclusive right to make a copy, and more importantly, the issue of who makes it in the digital context. Now, our Court of Appeal, all right, essentially followed the decision in the US Court of Appeal's decision for the Second Circuit in the Cartoon Network decision. And in Cartoon Network, the US Court of Appeals held that Cablevision's proposed remote storage digital video recording service, a similar one, the same kind of service, did not directly infringe the reproduction rights of those holding copyrights in the recorded materials on the grounds that there are two volitional acts in that case. They use the word volitional acts. The first one, that of Cablevision in designing, housing, and maintaining a system. That is the RSDVR, that exists only to produce copies of the specific programs. And B, that of Cablevision's customers who operated the RSDVR by ordering it to produce copies of the specific programs. Now, the US Court of Appeal was of the opinion that in determining who actually makes a copy, a significant difference exists between making a request to a human employee who then volitionally operates the copying system to make the copy and issuing a command directly to a system which automatically obeys commands and engages in no volitional conduct. Therefore, in Cartoon Network, the volitional conduct that resulted in the making of a copy of the specific programs was that of the customer who operated Cablevision's RSDVR. So similarly, the Court of Appeal in Singapore, in Record TV, followed the reasoning and affirmed the decision of the lower court and concluded that the functionality of the iDVR was essentially the same as that of the traditional DVR or VCR, in that A, it was the user who chooses the show, who chooses which show to record. B, the request to record a show was made to the recording device in the traditional DVR or recording system in the iDVR. And it was this system which recorded the selected show. So the conclusion was that the registered users of MediaCorp were the makers. They made the copy in this particular case. The same scenario, the same factual matrix happened in Australia in TV Now. And the full court of the Australian Federal Court of Appeal arrived at a different conclusion. Like Record TV, the defendants, Singtel Optus, provided a new subscription service, TV Now, which enabled a subscriber to have free-to-air television programs recorded as and when broadcast as and when it's their broadcast, and then to be played back and watched at a time or times that they choose. Now, the central issue in TV Now was when a film or a copy of the film and a sound recording were made when a television broadcast of one of the football matches, the copyright in which was then owned by the plaintiffs, were recorded for a subscriber, and who, for the purposes of ascertaining copyright infringement, was the maker of this film or the sound recording. There are possible answers, all right, to this question. 1, Optus. 2, subscribers of Optus TV Now. C, Optus and the subscribers jointly. The judge in the lower court concluded that the subscribers of Optus TV Now made the copies, and this was a conclusion similar to Singapore's Record TV, Court of Appeals decision. However, on appeal, the full court disagreed and held that the maker was Optus, or in the alternative, it was Optus and the subscriber. An important part of the court's judgment is the meaning of make within the wording, all right, of sections 86 and 87 of the Australian Copyright Act. And we have in Singapore basically similar provisions, all right. In our own act, it was 83, all right. And the full court found that the following acts were relevant in the analysis of a direct act of copying on the part of Optus, and consequently, the court said, the acts created a nexus sufficiently close and causal to the copying of the broadcast to affix liability onto Optus. So the court identified that it was solicited subscribers' utilization of its TV Now service, design and maintain a sophisticated system which can effectuate the making of records wanted for viewing for subscribers, stand ready and remain available to implement the subscriber's request at the time when its recording controllers poll the user database and receive a response indicating that a recording has been requested, capture the broadcast, and embodied its images and sounds in the hard disk, made 4 copies of the requested broadcast to accommodate the 4 types of compatible playing devices on which a program could be viewed by the subscriber. So in the words of the full court in Australia, Optus is not merely making available its system to another who uses it to copy a broadcast. Rather, it captures, copies, stores, and makes available for reward program for later viewing by another. In other words, the full court of in Australia did not consider Optus TV Now a mere intermediary in that sense, which absolves responsibility. It was directly involved in the doing of this restricted act, which was the making of a copy of the film or sound recording in the relevant broadcast. And it was manifestly clear that Optus, all right, was the maker, but it was also clear to the court that without the human user, all these chain of acts would not have taken place, all right? So, the court therefore said that it could not have happened but for the initial action of the subscriber in making a request to record on the TV Now service. Therefore, the court concluded that for the copies of the broadcast to be made, Optus and subscribers acted in concert with a common design, i.e., the production of the selected program for transmission to the subscriber. And based on this, they were said to be jointly and severally responsible for the act of making the copies. So, TV Now, the judgment in TV Now, offered a different approach to the inquiry. And the different outcomes on a similar set of factual matrix highlight the increasing complexities within which copyright infringement actions are pursued, particularly in a digital context. Now, in the context of an increasingly automated process of copying, it would be increasingly important and necessary to have a test to help determine liability. So is the volitional conduct test an appropriate test? That was a test, propounded in Cartoon Network. It appears to have been discredited, but it was followed by the Singapore Court of Appeal. Or are we really looking at the issue of proximate causation, something which the full court in Australia appears to allude to, that there was an establishment of a sufficiently close nexus, proximate nexus, such that Optus is not just facilitating a conduit, but was actually involved in the act of making a copy. So these are areas in which I think more work has to be done. Certainly, there can be a lot more cross fertilization of ideas, all right, between perhaps intellectual property law and other areas of the law, such as tort law, all right. I think, Christina, how much more time?
Another 10 to 15 minutes.
Okay, then I'll very quickly just move on. Besides the who makes the copy, the other issue there was two issues that were important in Record TV. One was who communicates the work to the public. All right, the lower court concluded that Record TV communicated. All right, found in favor of MediaCorp. The Court of Appeal disagreed. Essentially, there was no communication to the public. All right, because of the court's interpretation of who is the public. I think here also over here you too have this issue of who is the public, whether this has been communicated to the public. Now, there is no definition of the public in the Copyright Act in Singapore. All right, so the court was asked, is this a communication to the public? Who is the public? What was again interesting was that the Court of Appeal concluded, all right, that that there was no communication to the public because, number one, the registered users held valid TV licenses with MediaCorp. So the contractual relationship between MediaCorp, who is the unit, the business entity that are broadcasting all these free-to-air programs, the relationship between MediaCorp and the registered users arising out of the license rendered the registered users arguably not the public. All right, that was one reason. Second reason, that each communication, and this is the part which I think that maybe our Court of Appeal has got it wrong. All right, is this recorded? It is, right? Maybe they would not have an opportunity to watch this, all right? With all due respect, I think maybe, all right, they have gotten it wrong, all right? Because the second reason is that each communication to the registered user was made privately and individually, and the court therefore concluded that the aggregate of all these private and individual communications did not transform these otherwise private and individual communications into communications made to the public. I think this is flawed. All right, because what the court is saying is that if I communicate just one-to-one, because each one is private, then the aggregate of all these communications that I make is not to the public. It's still private. Now, this, I think a lot of us feel that maybe they need to rethink this a little bit. All right, and it has been argued by scholars and commentators, all right, in Singapore, that maybe, that maybe there's more to this, all right, and that it was suggested that the inquiry ought to be answered in accordance with guidelines adopted by court elsewhere, for example, in Australia, and here, all right, the European Union. And that is whether communications, all right, of the copyright work were made in a commercial setting. And if it was so, then it is to the public. All right, anyway, all right, this is a difficult area, a difficult, not everyone agrees, all right. I think you're familiar with the recent decision of GS Media, all right, here, all right, and also there is the Ariel decision in the US, and the Supreme Court in Ariel, all right, concluded that this individual type, is still communication to the public. It is not private, all right? So in an ever-changing world of the internet, I expect that before long, our courts will be called again to determine whether communication of a copyright work is made to the public, and I think they will probably have to do a bit more of I don't know, right, to deal with this particular issue. Maybe they really have gotten it not quite right this time, all right? Then the other inquiry is, was there copyright infringement by authorization? Now, since, all right, the court found that it was the users who made the copy, then it became important to ask, is there an indirect infringement, all right? And in Singapore, indirect infringement is a concept of authorization, which is similar here. All right, and I will not go into that because of time. That's quite a lot to cover, and they applied the guidelines. All right, and then they concluded that there was no authorization. So essentially, Record TV, all right, case came as a surprise to many, when the case was going on, it was more like a small startup against a big, strong company, all right? And when it won, all right, this small startup was cheered on, that this is in the kind of context in which, all right, copyright is very bad, all right, and hindering innovations and so on and so forth. So some reflections, all right, on the Singapore Court of Appeal's decision, all right, in Record TV. I think this case has brought to focus the conflicting interests and values, such as upholding and preserving the property rights of copyright owners, the public interest in not allowing these same property rights to hinder creativity and innovation, and the public's interest in the use of these new technology. Now, I think it's a difficult thing for the court as well, all right? It's very clear that amidst all these conflicting interests and values, a choice has to be made that we have to allocate, right? And the responsibility must fall on someone. And the Singapore Court of Appeal made that choice, I think, that public interest is better served by encouraging rather than stifling the use of novel technology, especially in light of the fact that copyright owner, in this particular case, has apparently not suffered any loss from the use of the IDVR service, since the registered users were licensed to view the relevant copyright shows because they are subscribers. So because of that, all right, I think Record TV, its decision is driven and it is by policy. All right. Now, of course, this is another big area in which whether judges should do that. All right. But I just want to read to you what V.K. Raja, Judge of Appeal, said in Record TV. Although copyright law is intended to promote creativity and innovation by granting exclusive rights to copyright owners to exploit their rights for a specific period of time, there is also a public interest in not allowing copyright law to hinder creativity and innovation. Rights conferred on copyright owners are statutory rights. In our views, where the statute is not clear as to the ambit of an existing copyright owner's rights, and the courts are asked to expand those rights so as to respond to novel technologies impinging on the copyright owner's interests, the courts must strive to strike the right balance between the copyright owner's private rights and the public interest in the use of new technology. Thus, unless the statutory words clearly reflect the legislative policy on the extent of the rights to be conferred on the copyright owner, the courts should not be quick to interpret the statutory words expansively if doing so may stifle technological advances which are in the public's interest. So this is essentially the reason, I think, all right, that has very much influenced, all right, the court. Now, I come from the business school, all right, and so one of the issues that we often discuss in class is what are the business implications for this, and did Record TV, was it really a victory for Record TV, all right, from a business perspective? Now, it's been more than 6 years since Record TV successfully appealed to the Singapore Court of Appeal against the lowest court ruling in favor of MediaCorp. Now, recent journalistic reports put Record TV on a expansionary trajectory. This was what was found. Since its inception, Record TV was solely funded by its own capital and a grant from Spring Singapore, which is a unit to encourage startup. All right. It relied mainly on advertisement to stay afloat. Despite its initial win against MediaCorp, the road ahead for Record TV is, in my opinion, a very challenging one. All right. First, foremost of all, Record TV must monetize its service and develops a sustainable business model which is revenue generating. It should be noted that Record TV does not generate or create contents. It is a tech company. It has no relationship with broadcasters and content providers. What it offers is a technology which functions like a video recorder, allowing users to access publicly available contents on the internet. Without contents of its own, the growth of technology provider companies like Record TV would be limited, as they will continue to face the threat of legal proceedings from content generators. Big market players like MediaCorp could easily acquire similar technology, and they have done so, offered by Record TV, and coupled with the width and the depth of their contents, they are poised to dominate in terms of market share. And this was precisely what MediaCorp has done. They launched Toggle very soon, shortly after the ruling, and this, to me, is testimony of what is to come in this marketplace. Therefore, it remains to be seen whether Record TV will continue to thrive after its attempt to monetize its service. I think I have barely scratched the surface, all right, of this topic on copyright liability of internet intermediaries in this evening's talk. I think the issues are indeed numerous, and complicated. We began with a broad macro overview, and then we moved in to study a micro issue to highlight the challenges faced by the courts in grappling with the legal analysis in this area. Many scholars and commentators have written extensively in this particular area, and in this room, Professor Christina, Professor Christoph, Professor David, and of course my teacher, all right, Professor Lionel Bentley, have all written, all right, and you should all read the work, all right. So it is, you know, I think I could, maybe I could say this, I don't know, all right, that there is some consensus that differences in national approaches to the complex issue of internet intermediaries and indirect copyright liability, as well as the limited liability, also known as safe harbor immunities models, perhaps not particularly helpful in an interconnected and transnational digital environment. We are fragmented, all right? There are different approaches, different ways of looking at the same issue. So there is certainly merit in the argument for consistent global laws which will support the markets for the use of digital content. Now, the bigger challenge, I think, is how are we going to bring all these various stakeholders to the table and help them work together to put in place an international framework that harmonizes and prescribes the elements of internet intermediary liability and the defenses to such a liability. There's a very recent book, TRIPS Plus 20, from Trade Rules to Market Principles, and in that book there's a chapter by Professor Seth Erickson, and he talks about the commodification of internet intermediary safe harbors, and he is asking to avoid a premature harmonization around a suboptimal standard, which essentially is that there is no leadership now in this particular area, and the US, all right, way of bilateral and avoiding the multilateral contacts, all right, is to him not the best way forward by incorporating the safe harbor provisions via the free trade agreements. So this is the view of one scholar, and I think there is much work to be done indeed. I'm looking at the future, all right, in this particular area. Bright, talented, and young scholars like yourself, and we look to your leadership, right, in helping us solve these problems that we face in this particular area. I think I have well exceeded the time allocated to me, Christina, and I'm going to stop speaking here. Thank you very much for your kind attention.